Welcome to the Environmental Law Institute. My name is Brett Cordy. I'm the director of our Associates program, which is the department here that brings you educational programs like today's and like our summer school series. You've joined us for NEPA, ESA, and Fundamentals of Environmental Law. This is a public ELI seminar and the second session in our 2017 summer school series, which runs every Thursday through the end of July. I encourage everyone to sign up for the rest of those webinars or seminars if you're able to, as we will be getting into the basics of most federal statutes and general environmental legal regimes throughout the rest of the summer. For the audience in the room, when we get to the question and answer portion of today's program, please let me get you this microphone so that we can capture your question for the webinar participants. If you're joining us via webinar, hi, thanks for being there. You can submit your questions through GoToWebinar's question box, and we will get to those when we get to that portion of the program as well. But please don't wait to send your questions if you're online. Send them as soon as you think of them, and then we'll be able to get to them when it makes most sense. Video and audio recording of today's discussion will be available on our website within the next week or so. Full speaker bios are posted on the event calendar on the event page. But I will briefly introduce our two panelists who have been so gracious to join us. This is at least third
year for me. Been doing it longer, maybe?
I don't know.
A few years for all.
Let's see. Yeah.
So first we have Jamie Auslander, who is a principal at the law firm of Beveridge and Diamond. Jamie devotes a significant part of his practice to counseling and litigation under the National Environmental Policy Act, NEPA, and similar state laws, or the little NEPAs. He has represented public and private clients in building strong administrative records and robust NEPA analysis to support complex projects and proposals. And in the second half of our presentation today, we have Jane Davenport, who is a senior staff attorney with Defenders of Wildlife. Jane has been with Defenders since 2013. Her work there centers around the Endangered Species Act, Clean Water Act, NEPA, Marine Mammal Protection Act, federal admin law, and federal wildlife and fisheries law. Her litigation and legal advocacy work for Defenders of Wildlife focuses on two main areas. First, protecting marine species such as sharks and sea turtles from direct and incidental take in fisheries. And second, protecting freshwater species from habitat destruction and pollution. So the format of the seminar is Jamie's going to cover NEPA, and then Jane takes over and does ESA. We'll come to questions after both of those presentations. So without further ado, I will hand it over to Jamie.
Thank you. I don't know to be offended. I think usually we're the first in the summer series, so we're second. Okay, all right. Careers are unimportant as long as you know NEPA and ESA. So, really thrilled that there's so many people here and on the line want to hear about NEPA and ESA on a sunny summer afternoon or second day of summer. Again, my name's Jamie Auslander. I'm with Beveridge and Diamond, and Beveridge and Diamond's an environmental law firm. That's basically all we do. We mostly represent the project developers, states, municipalities, private companies. They're looking to build stuff. And often when you're building a large project, you're going to need a federal approval, federal funding of some kind, and that triggers NEPA. It also triggers the need to often get coverage under the Endangered Species Act and all the panoply of other laws that you've heard. So we hope today will be a good a primer on these laws, and we're also going to cover sort of the basics of environmental law that kind of give you a lead in to some of the things that you're going to cover in later summer school sessions. So just to start, Jane and I are here. We're here for until 2 o'clock. We're going to leave some time for question and answer. We're going to try to cover as much as we can under these statutes, but I teach a full day on just NEPA pretty regularly, and so we will try to cover the basics, but we can't cover everything. And so please, we do encourage your questions both during our Q&A and afterwards. Jay knows NEPA as well as I do, ESA, whatever that it is that you have, and happy to keep the conversation going after this. So let's just kind of set the stage for where NEPA and the ESA fit into all of this. Late 1960s, not much going on. The price of a gallon of gasoline was about 35 cents. no such thing as mobile phones. But the United States was, heavily industrialized, and the impacts of that were becoming more and more apparent. And there was really a rising environmental consciousness. And it manifested itself in Congress, including the Richard Nixon administration. And really it's a debate about what to do. There were sort of one-off statutes like the Wilderness Act, and there was a predecessor, the Clean Air Act, but there weren't really big comprehensive laws. And really the universe of laws that we deal with day in and day out were passed within a fairly narrow period during the 70s and the 80s. And as is so common, what kicked this all off was a calamity. In the case of NEPA in 1969, there was the massive blowout about 3 miles offshore of Santa Barbara, and that at its time preceded Deepwater Horizon, but that was a huge oil spill, a lot of wildlife, and it really was a big deal. So we what Congress decided was the best thing to do was to declare a national environmental policy, and the supporters argue that without such a policy, federal agencies whose own approvals and actions were seen as significant sources of pollution would be unwilling and unable to assess the environmental impacts of their actions before it was too late, before they actually committed to undertaking their actions. So Congress overwhelmingly passed NEPA, which is the National Environmental Policy Act, and President Nixon, of all people, signed it into law in 1970. And that sort of kicked off a slew of events like potato chips, environmental laws. You can't just have one. So you have the EPA is created, you have the Clean Air Act, Clean Water Act, the Endangered Species Act, RCRA, Resource Conservation Recovery Act, Circular, better known as Superfund. These are all subjects of separate sessions and summer school events, but today we're going to talk about NEPA and ESA, but this kind of family of laws, I'll go back, really is the core of what remains today. There are new regulations, new guidance, but the core statutes really have not changed very much, and that's a good thing and a bad thing at the same time. Also, just so we're going to be talking about different kinds of authority, just so we're all on the same page, we have lawyers and I think some non-lawyers in the room. When we're talking about laws, there's a hierarchy. So what lies at the top, the U.S. Constitution, that controls everything. There are actually a lot of issues under the Constitution and environmental law, takings under the Fifth Amendment, preemption under the Supremacy Clause, interstate commerce issues under the Commerce Clause. So these issues kind of come up a lot in our area of the world. Anybody who's had constitutional law? No, if you haven't, take it. Under the Constitution, we have statutes that have been issued by Congress. That was the list that I showed on the prior page. The statutes are control over everything but the Constitution, and statutes that are inconsistent with the Constitution can be challenged as unconstitutional and struck down. And then below statutes, we have our agencies, our federal bureaucracy that issues regulations, and often the statutes will leave significant gaps to be filled, and they need to adapt to changing conditions, and that's where the regulations come into play. These are issued through very formal processes issued in the Code of Federal Regulations. They have the effect of law. The agencies have to follow their regulations unless they change their regulations, and that has to follow the same process. Under regulations, we have case law, courts interpreting both statute and regulations where it's unclear, and the case law will be binding. Supreme Court, of course, at the top, nationwide. Federal courts of appeals, there's 11 of them in the D.C. Circuit also, will control in their respective regional areas, and then district courts. So case law, particularly in NEPA and ESA, has really grown up. A lot of this law has grown up through what courts have done over time. And then there's agency guidance and executive orders. Of course, this latest administration is a big fan of executive orders. These don't have the force of law. They're not binding, but as a practical matter, federal agencies follow them. So they're important in terms of giving some certainty, some guidelines to the regulated community as well as to agencies how they should be administering. These things change based on who the administration is, based on what the individual issue is. But one of the big issues in environmental law is, what is guidance? What should be guidance? What should be regulation? What is, what's being done by guidance that should be regulation, etc. So anyway, you have to kind of be aware of all of this stuff that's going on. But I wanted to give a grounding to when we talk about statutes or regs, you guys know overall what it is that we're talking about. Okay, so what is NEPA? If there's any Star Wars fans out there, if you're the federal government or you're a developer of major projects, it's kind of like the Force. It's pervasive. It's all around us. It could be the Death Star. It's more the ESA. I think it's the Death Star. But it's all around us. It's always on your mind, and it's mainstream. Here's a personal example. Some of you may have seen the press conference that President Trump gave. I think it was a week ago, last Friday, where he talked about a project called the Intercounty Connector. That is a road project about 20 miles north of the Beltway that connects I-270 and I-95. It's an east-west corridor. And the president talked about that and then held up this big analysis, this environmental impact statement that prepared under NEPA, and then proceeded to literally trash it, literally throw it on the floor. This had personal significance for me. My wife said, look, the president's talking about the Intercounty Connector. I said, great. Because I personally worked on the Intercounty Connector for several years, and I helped write that environmental impact statement, and I helped defend that environmental impact statement in court when it was challenged. And so literally, if you've never had the privilege of watching the president throw years of your life on the floor and kick it away, it's worthless. I highly recommend it. But it just sort of brought back that this is a real issue. It has mainstream appeal, and it really is a source of consternation for real people, as well as active reform. And there's perhaps been no greater impetus politically for change than we do have now for NEPA. But I want to point out, walk away, if you don't walk away with anything, just walk away with 2 points here. First, NEPA's not going anywhere. So, again, it's terrible, it's great, whatever. It's been around since 1970, the statute, and you need to be, amended by subsequent act of Congress. There's no indication that NEPA really is part of us culturally now, that agencies, when they act, when they grant approvals, when they fund something, think about the environmental consequences of what they do. It's really just in there culturally. The second is that on the other side, talk of reform doesn't mean that we're gutting the environmental process. There are ways to do the NEPA process better, more efficiently, without sacrificing the robustness of the analysis. And again, those are kind of like the forces that are pulling right now, and as we decide, what it is that we're going to do. At least for the next 4 years. But back for basics. So NEPA, we talked about statute. Here's the statute. It's in the U.S. Code. There are regulations implementing NEPA. At the top is within the White House is the Council on Environmental Quality. The CEQ promulgates regulations under NEPA that apply to the entire federal government, but it also directs each agency to file its own to come up with its own NEPA regulations and to revisit those regulations from time to time and amend them. So each department, each agency has its own NEPA regulations, and sometimes sub-agencies have their own regulations. And then below that you have guidance, as we were talking about, rules of the road that are not binding, but as a practical matter do heavily influence how reviews are conducted. So, example of what might be in guidance or in individual agency regulation, Department of Transportation has regulations on what types of projects typically require the most rigorous review under NEPA, under environmental impact statement, types of decisions that normally only require an environmental assessment, and then types of decisions that could be disposed of with a categorical exclusion. Because we've done them so many times, we know that they don't have significant impacts based on what the kind of approvals and things that the agency does. These are individualized to individual agencies, and again, they need to continually re-examine them every few years to ensure they're up to date. Do they always do that? No, but they're heavily encouraged to on all sides. I've also made some other resources available. Should be attached to the materials available after this webinar, but there are a list of other primary NEPA resources issued by CEQ, some guidance. One guidance is called the 40 Most Asked Questions. That's been around since the 80s. It still has a lot of cachet today. some other agency guidance on NEPA. It's good summer bedtime reading if you need that. So NEPA, again, we're approaching 50 years. Big thing, it's called the National Environmental Policy Act, not the National Environmental Protection Act. That mistake is made a lot. What Congress envisioned NEPA to be is a procedural statute. It does not require a particular result. It does not require you to pick a particular alternative or a particular kind of project. It just requires that you look before you leap, that you understand what the impacts are going to be, and that the decision maker have that information available when he or she makes his or her decision. But again, just last month I got a NEPA complaint alleging a failure to comply with the substantive aspects of NEPA, and it's still heavily litigated, though it's pretty black letter that it is a hard and procedural statute, as opposed to the Endangered Species Act, which is very substantive, maybe the most substantive statute we have environmentally on the books. So NEPA requires federal agencies to prepare a environmental impact statement, or EIS, in connection with, and here's the trigger, proposals for major federal actions significantly affecting the quality of the human environment. That's a mouthful. But what it essentially means in practice is that every federal agency discretionary action is going to trigger NEPA. And again, that includes approving a project, financing a project, giving technical assistance, conducting plans, projects, programs, issuing rulemakings. All of these things ultimately trigger NEPA. But some of these things are really important. We're talking about proposals, and that's a term of art under CEQ regulations. So what that means is that an agency has a goal and is actively preparing to implement that goal. So we want to make sure that we don't do NEPA too soon when there's insufficient information about what action the agency proposes to do and what types of effects it would have. We also don't want to start it too late, which defeats the purpose of stop and think. If the agency's already predetermined what they're going to do, there's really no point in doing a NEPA analysis because it's not going to affect the decision. So again, kinds of decisions that trigger NEPA, approval of a fracking well on federal land by the Interior Department, Forest Service adoption of a forest management plan, construction approvals for a state highway that uses federal dollars, Fish and Wildlife Service issuance of a permit for incidental take of endangered species, offshore wind regulations, all of these that trigger NEPA. And if you ever look at rulemaking in the Federal Register, you always see a National Environmental Policy Act section where they talk about how they disposed of, or how they satisfied the NEPA review requirement. But it's not ubiquitous. We don't always have to do NEPA. So, for instance, the court's decisions. Courts don't need to comply with NEPA. There's no NEPA for the issuance of a court decision. Legislation, Congress doesn't have to follow NEPA when it issues legislation. Purely state or private actions, they're not federal agencies, so they don't have to satisfy NEPA, though in some states there are little NEPAs that they have to satisfy, and particularly in California, it's a very different kind of NEPA. It's a very substantive NEPA. So get away from the federal, but you still need to comply with state requirements. Approvals that come directly from the President of the United States, those don't trigger NEPA because the President is not a federal agency. Some agencies are non-discretionary. Some decisions are non-discretionary. So where a law requires that an agency do something as a ministerial action without any, weighing of different factors. There's a growing number of court cases that exempt those kinds of decisions from NEPA. Again, why? Because there's no point in doing the analysis when the analysis can't affect the decision at the end of the day. Certain EPA actions under the Clean Air Act and Clean Water Act, Superfund site cleanup, some of these have been exempted either statutorily or by courts from NEPA. Again, because there are similar processes, functional equivalence is often used, similar processes, similar environmental considerations that go into those decisions. So to require another NEPA analysis on top of that is either unnecessary or duplicative. What about environmentally, quote, beneficial actions? That's a closer call. Courts are split on that. One example is in the 9th and 10th circuits where they come to different conclusions about whether Endangered Species Act designation of critical habitat displaces NEPA. Does it or doesn't it? That's a bit of a closer call, but NEPA does cover both beneficial impacts and adverse impacts, and that much is black letter. What about a project where there's only, it's a really big project, but there's just a small federal nexus, a small piece. You need to cross a bridge that crosses a water, but it's part of a 100-mile project. Does that trigger NEPA? And again, that can be very case specific. There really are no bright line rules here, and that's what we typically call the small handles issue. How much is necessary to federalize the entire project, and when NEPA is triggered, how much of the project needs to be considered under NEPA. So in short, federal actions under NEPA are those that are potentially subject to federal control or federal responsibility. The first thing we try to tell our clients is, can you style the project that you avoid NEPA? It can. You can do that sometimes. If you reroute it, you don't need a federal permit because you're not going to cross a water body, or you're not going to across federal land. Sometimes you could do that, but a lot of times you can't. Sometimes it's just a necessary step that you need to get through. Okay, one other core issue, if we have to do NEPA, what are we doing NEPA on? What is the project? What are we studying? And that's a great question, and the answer is, again, it depends. It's really important at the beginning of the project to take the time to define what the project is, to really fully consider the scope. If you take a large project and you split it into smaller projects, that each one of those smaller projects have insignificant impacts, that's the cardinal sin under NEPA, and that's called segmentation. The test of segmentation is whether each one of those projects has independent utility. If you have a 10-mile road, you split it into 1-mile segments, you wouldn't have built any of them except for the whole road. That's not going to be kosher under NEPA. But there are closer calls. FERC has run into that with natural gas pipelines. How much is the project? What is an independent utility project? Those are issues that are frequently litigated, and it depends again on the cases and the circumstances how they come out. Okay, so who's doing the NEPA? I'll call them the players. So you first have to identify the lead agency, and this isn't immediately obvious. Sometimes it is. You're building a railroad, Federal Railroad Administration may be the lead agency. You're permitting under the 404 permit under the Clean Water Act, U.S. Army Corps of Engineers would be the lead agency. But sometimes it's not obvious. Sometimes there are co-lead agencies. Sometimes when a state is a sponsor of the project, the state and the federal agency with jurisdiction can be co-lead agencies for NEPA. Then there are cooperating or participating agencies, and these are agencies either that have a permitting role in the project or have a special expertise to bring to the project, and they have a special seat at the table. Other agencies just kind of hang out there. They're resource agencies. They can be consulted, but they aren't. They don't actually have a particular approval in a project. Yes?
I was going to say on this, I think, this is one of those key issues you always have to identify, who's your lead.
Right.
And sometimes it's specified by statute. So, you really need to know what agency is lead under what statute. For example, FERC under the Natural Gas Act is designated the lead on NEPA, but it may bring in Fish and Wildlife Service if there's an ESA aspect, or the Army Corps if there's water body impacts. So, you can't just look at NEPA and the regs. You have to look at your agency enabling statute. But CEQ has also put out a list of, if there's a water body impact or, whatever it is, some agency is going to be a cooperating agency. So it's the kind of thing you have to have a big enough scope of your vision so you understand where some of these might be defined for you. You can't make assumptions.
Right. That's true. And as a project proponent, there's a role for you to play there too when you're first talking with the lead agency, making sure that the lead agency has no blinders on, sufficient. You often see a matrix of things I need to get and who I need to ask to get them and how long it's going to take, and that's a very useful exercise. It's painstaking, but it's really important so that you don't forget something or something, it's not the least common denominator that's slowing you up at the end of the day, because of course you can't proceed till you have all the required approvals. One question I'm often asked, I'm a private developer, can I participate in the NEPA process? The answer is yes. Again, there's a lot, big role for private project proponents to play, and it makes sense, right? Who knows the project better than the proponent of that project, who's probably spent a lot of time designing it, finding supporters for it, finding financing for it before it even saw the light of day or was an application to a federal agency. So there is a role to play, but there often can be additional ways that private developers can accelerate, and one way to do that is to basically enable consultants, third-party consultants. There are entire cottage industries built around NEPA documentation. In a typical situation, the federal agency will retain a private contractor that will be funded by the project developer, and that contractor works for the agency, doesn't work for the developer. So the money is paid by the developer, but the contractor answers to the agency, and the agency, of course, has to review independently everything that the contractor is doing. There's different, depending on the agency, it depends how much how much the project opponent gets to interact with that contractor, gets to play. And from my perspective, the more interaction among everybody, the better. But again, the animating principle from the federal agency is they don't want it to look like private parties are driving the process, that they are remaining in control. So that's the thing, and that's a balance, and there's ways to do that through agreements on the front end so that you avoid any of those types of allegations. But again, with these players, there are inherent problems, right? So again, the Department of the Interior can be involved in a project in a couple of different capacities. The Bureau of Land Management administers federal lands, may be permitting an oil and gas drilling pad. At the same time, under the same Department of the Interior, you have the Fish and Wildlife Service, right, who's primarily a resource agency, and so they'll have their concerns will be wildlife and biological concerns, and so getting different agents, even sister agencies within the department, onto the same page, onto a schedule, committing to process the applications and ultimately reach a final decision in a efficient manner is challenging, and that's again sort of one of the areas of consternation that's fueled the calls for reform. So again, very basics. NEPA applies. Now what? The big trigger that you should look at, again from the prior slide, is significantly affecting. Right? Does the action significantly affect the quality of the human environment? The answer could be yes. The answer could be no. The answer can be I don't know. Right? So there's three possibilities. Let's just talk through them. So first, what do I mean by significant effect? What is that trigger? And it's case by case. So there's context concerns, and there's also intensity concerns. Context means you're not looking at effects in isolation. So if I'm going to fill, I'm going to build a shopping center. I'm going to fill in 3 acres of a wetland. It's different if I'm filling in 3 acres of a 2,000-acre wetland, or I'm filling in 3 acres of a 6-acre wetland, right? I mean, that's a very different impact that you're going to have. That's really what context is about. Intensity is about the severity of the impacts. And a couple key takeaways, again, as I noted before, adverse and beneficial impacts matter. You want to look at whether it's a unique geographical area. You also want to look at any uncertain risks, things that agencies haven't looked at before. Special kind of project presents new sorts of things that we need to look at more closely. But agencies do not need to consider remote or speculative impacts, and this is really important when we're talking about issues, on the fringe. Climate change has lived there for a long time. How do we deal with that? I think we'll get to that in a few minutes, but black letter that you got to consider it in some way, shape, or form. But to what extent? How far do you have to speculate in the future? My project, what effect is it going to have on climate change? You do not need to crystal ball at the end of the day. Again, effects. What kind of effects are we talking about? Ecological effects, aesthetic, historic, socioeconomic. But the important point to go back to is we're looking at the effects on the environment. We're looking at socioeconomic effects. We're looking at it as they pertain to environmental effects. So, one example, which often comes up in environmental justice kind of context where you're going to build let's say you're going to build a factory, right? And it's going to emit X amount of X pollutant or X amount of Y pollutant, but you're going to cite it here instead of here. But there, where you decide to cite it, there's a large community, the poor, minority, just otherwise disadvantaged community that will be disproportionately impacted by placement of the project there. Those are the kinds of things that you want to think about on the socioeconomic spectrum for impacts. But just purely economic ideas, is it a good idea? Is it good use of taxpayer funds? Those ideas typically don't get pulled into NEPA, but they do sometimes. I was at a hearing just a couple weeks ago regarding a project called Purple Line, which is a light rail project. Again, kind of not far from the ICC, but it's going to connect Montgomery and Prince George's counties. And the judge there found that all of the environmental claims under NEPA were not properly founded, so dismissed them, but found that there was an issue regarding ridership, whether there would be enough riders on Metro Rail to connect to the light rail system, and whether as a result of that it was a good use of taxpayer funds. And right now it's going to be appealed to the DC Circuit, but again, this happens. But I would say that kind of effect is not a NEPA concern. That's a public finance concern, elected representatives concern. Anyway, I'll get off my soapbox now. Three different lenses that we have to look at for these effects. One is direct effects. It's caused by the action, occurs at the same time and place as the action. So if I'm cutting down trees and I'm filling wetlands to prepare land for construction of a shopping center, right? The cutting down of those trees would be my direct effect. Indirect effects are caused by the action but occur later in time or further at a distance, but they're still reasonably foreseeable. So if I'm building a highway, the land I clear to build a highway would be a direct impact, but there also will be growth-inducing impacts. If I put a highway there, businesses will be attracted to there. More residential, population growth will be triggered, and those effects on the environment would be indirect effects. And then lastly, there's cumulative effects. You want to look at the incremental impacts of the action when added to other past, present, and future actions, reasonably foreseeable future actions. So you want to make sure that you're not analyzing your project in a bubble. You want to know everything that's going on around you and know what the cumulative impacts are going to be. But again, when we're talking about effects and we're talking about significance, right? We just talked about what significance means and what kind of effects we're talking about. Why does it matter? And it matters because it determines what level of review we're going to do to satisfy NEPA. The key thing to remember when you're thinking in the mind of an agency is that an agency legally can always do more NEPA. It could be the smallest project in the world, and an agency can decide to do an environmental impact statement, full blown. And there's no recourse for doing that. You can't go to court and challenge the agency for deciding to do an EIS, right? At the same time, where an agency gets into trouble sometimes when they've done too little NEPA, one of the biggest claims where an agency either does an environmental assessment where they should have done an environmental impact statement. That's a procedural claim under NEPA. You see it all the time. And then they can get dinged and they have to go back and do an EIS. So there's a sort of risk aversion that pushes towards more paperwork and doing more. I think that's led to the multiplication of EISs and even EAs being almost the size of EISs, and it's a fear of litigation. So that's something that we need to squarely address if we're going to approve this default to more paper. So categorical exclusions, you don't hear about them as much, but Cat X's are by far the most common form of NEPA compliance. And CEQ defines them as a category of actions which do not individually or cumulatively have a significant effect on the human environment. So these are things that we've done time and time again. They're administrative actions. They're things that don't have on-the-ground impacts. So they're things that have impacts that we've studied them so many times that we just know going and doing it for the umpteenth time, it's not going to have significant environmental impact. So we could dispose of it using a categorical exclusion. Some of these are specified by statute. Some of them are specified by regulation. There was recently guidance by CEQ on how to promulgate categorical exclusions, how to periodically review them and ensure that they are sufficiently robust. So, Department of Transportation has, construction of bike lanes, installation of traffic signals, internal organizational actions. I mean, these things can be approved or weeks or at the most months. So most common form of NEPA compliance are CADXs. Big qualifier though is you have to determine that there's no unusual circumstances in a particular case that would preclude use of that categorical exclusion. So example, you're doing this for the umpteenth time, but there's a particular endangered species known to exist there, or there are particularly sensitive wetlands that exist there. You'd have to give a second thought to whether I'm going to use that CADX. Environmental assessments are the next level up. You're not sure if there's going to be significant impacts or not, or you can't get away with a CADX, but it's not going to require an EIS. You do an EA. Kind of a sad joke among NEPA practitioners. This guidance says that environmental assessment should be about 15 pages long, 1.5. I've never seen an EA that's that short. It normally goes to hundreds of pages with lots of supporting technical attachments. They look a lot and smell a lot like an EIS. So I often tell a client, if you're going to do something like that, just go ahead and call it an EIS. Because again, avoid the claim that you've done an EA instead of an EIS. So
can you just say something briefly about why agencies might choose to do EAs even when they're super long as opposed to EISs?
Sure. Well, I'm interested in your own take on that, but often, there's some more process that you need to do for an EIS. You have to issue. We'll get to the next slide. You have to issue a notice of intent. You have to give defined the comment periods. It's ultimately graded by EPA at the end of the day, but it's just often perceived as a time-saving, cost-saving device, and often their regulations again will specify that this is the kind of action that normally calls for an EA. So I would prepare an EA. What are your
I was going to ask, have you had clients who have wanted to do an EIS, but the agency has said, that's in the too difficult basket. We'd rather do it as an EA. Yes,
I have, and sometimes that's a weird spot to be in when you're a developer. I want you to actually do the EIS, but again, there's bureaucratically, there are people that are going to prepare this document, and an EIS means 2 years on their calendar as opposed to guidelines for 9 to 12 months for an EA. So if they can get away with an EA and get it off their desk, often that happens. Again, not all the time, but often there just needs to be that conversation at the beginning. Are we doing the requisite level of NEPA review? Not too much, and certainly not too little. One other I want to talk to you about is mitigated FONSIs, and what is that? So that is a project that would typically present significant environmental impacts, but we've included mitigation measures to an extent that it basically brings it down below the threshold of significance. What's the catch? The catch is you have to do the mitigation that you commit to. And CEQ has issued recent guidance on this also. There's a common term called paper mitigation. I'm going to do X, Y, and Z, but guess what? It never happens, right? Or it wasn't effective, or it was never financed. So you built the project, 5 years later, there's no money for the mitigation. Sorry, it's done. We want to avoid that sort of outcome. So if you're going to do a mitigated FONSI and you're not going to do the mitigation, then you open yourself up to claims later that could reopen the NEPA process. Environmental impact statements. Again, keeping an eye on the time. I warned you. The basic steps for environmental impact statement. These are your big programmatic decisions, or your mega projects, or where an agency's decided to do an EIS. Very small percentage. For example, over 100,000 Clean Water Act Section 404 permits are filed each year. Usually less than 1,000 EISs total that are prepared. Again, you can always do more NEPA. You can always get in that box, but if you don't need to be, you want to have that conversation with the agency at the outset. And again, I want to reiterate that regardless of you having to prepare an EIS, it does not require you at the end of that EIS process to select the most environmentally preferable alternative. So your level of NEPA review does not affect, at the end of the day, there is no requirement to select the best environmental alternative. But again, EIS versus an EA, there are more steps. There are more formal processes that you have to go, and the big thing I want to highlight is scoping. Scoping is very important. What is scoping? That's a public process, and it allows the agency to determine significant issues related to the proposed action, as well as exclude things that it typically looks at but just really aren't germane to that action. So if an action is going to fill wetlands, you know, Army Corps of Engineers is going to conduct a review. Scoping would also bring up ideas concerned about listed species that would have to bring in fish and wildlife. It would bring up other sort of, again, part of throwing that net large enough that you're encompassing all of your reviews and all of your agencies that you need. But the lead agency ultimately will set the ground rules for the EIS and the scoping process, and then following the scoping process, then you get involved in preparing the actual EIS. And every EIS kind of looks the same. I mean, it's not cookie cutter, but there is a standard anatomy. Statement of purpose and need. You look at the alternatives that will meet that purpose and need. You look at the baseline affected environment, where is my project taking place, and you look at the effects of each alternative on that environment. That's effectively your, and we talked about, you know, direct, indirect, and cumulative effects, and any mitigation measures. It's probably the most important part, though. Again, work at the outset can save you so much time later. Is the purpose and need statement. It really is the foundation. It dictates where you're not, you know, what your alternatives will be, what alternatives will be excluded from further review. And if your purpose and need statement is flawed, then the rest of your NEPA analysis is going to be flawed. And the good news is that the agencies get a lot of deference on purpose and need. Only one time ever has a purpose and need statement been struck down, ever. And they typically get it where rubber hits the road, and of course typically on the alternatives. Did you consider sufficient alternatives to meet that purpose and need? Did you analyze the all of the impacts of those alternatives? But you know, for the ICC project, for instance, you know, we worked a long time on building that purpose and need statement. It could just be a paragraph, but you know, very carefully worded and every word thought about. If we would have said, you know, the purpose and need was to build an 18-mile road in this corridor, that would have been too narrow. It would have predetermined the project. Doesn't leave enough room to actually have a meaningful analysis. Conversely, if it just would have been, you know, reduce congestion, I mean, that opens up, you know, the world to have tons of strategies to do that. So again, very important. The heart is the alternatives analysis. The key is a reasonable range of alternatives. You don't need to consider, you know, I want to build something. I don't need to consider flying cars. I don't need to consider, you know, a subterranean tunnel. Things that are practicable, things that can be, you know, readily achieved. But you have to consider a reasonable range. It can't be too narrow. And these ideas come through public comments. They come through the agency's own staff. And you have to consider alternatives that are put forward, and you have to explain why you've rejected alternatives that you don't want to carry forward at any point in the process. In draft EIS, you want to, again, look at the description of the affected environment and look at all the environmental impacts of your analysis. And then finally, you will issue a final EIS. Then after that, you've got a 30-day period. Usually, there'll be a record of decision. And when that record of decision is issued, then if you dislike the project, the record of decision, or the NEPA analysis, you can sue on it. But you have to wait for that ROD to be issued. And again, you can look at a little bit more about these in the slides. Supplemental EIS. We're not done yet. We're done with the EIS. Sometimes these things can take years, right? Things are changing all the time. There's new information. There's new regulatory requirements. Sometimes it's important. Sometimes there's substantial changes to the regs. Sometimes there's substantial changes to the action. You've lost a source of financing. There's a new route that's come to and you want to take your linear project that way. In those instances where it's going to be seriously different picture of the environmental impacts of your project, you may have to prepare a supplemental EIS. On the other hand, the NEPA process has to end at some point, and just because there's new concerns, you can't, as an opponent, keep submitting, new report, new information, new comment, and keep the process in a do loop. Ultimately, it has to end somewhere. There's a whole body of case law around there. What's the issues? And again, I cover this sort of quickly. This is all well and good, but in practice, the hard look that you have to do under NEPA has become a bit Herculean. A lot of roadblocks. Again, we talked about agencies not talking to each other, deadlines not being followed or even set in the first place. sequential rather than parallel reviews. One agency waits till they're done, and then before they can start, and then the next agency waits till that's done so they can start. It leads to a very long process, and it doesn't have to happen that way. But this is the recipe for getting a lot of paper and taking up a lot of time. But again, what's driving this? The agency always can do more NEPA, and they're mostly afraid of getting sued, and of course, getting sued and losing. But we have to be more nimble because we need the projects, we need infrastructure, we have to find ways to do this. Also, the stakes are really high. Again, we see common claims under NEPA. The administrative record is different in every circumstance, but the lawsuits typically involve the level of NEPA review, whether you consider all the factors and whether the action has been fully considered, whether you segmented it or whether you've included all of the impacts of it. The merits, the standard or review that courts apply is a rule of reason, and they largely defer to the agencies. But the agency needs to show their work, and they need to show it by the administrative record that's filed. So unlike other litigation where you have discovery and you have experts, this is Administrative Procedure Act litigation. Typically, complaints filed, there are cross motions for summary judgment, and then the court's looking at whether the agency sufficiently justified its decision in the NEPA document and in the supporting administrative record. You can't add stuff to the record typically after a decision because it wasn't before the agency when they made their decision. Now, we've been sort of at work in trying to reform this. Here's just sort of a litany. There have been legislative, presidential, administrative efforts to streamline the NEPA process. This mostly has happened in the transportation and infrastructure sectors, but it's pervasive. You look at this list, you don't just think NEPA. It really comes under broader measures aimed at streamlining. Big transportation bills that have passed often contain these provisions. They don't amend NEPA itself, but they contain time-saving provisions. We've heard promises about new infrastructure bill. We haven't seen that yet, but that's typically where you're going to see these sorts of things come through. The good news is, we are making progress. Things that are categorical exclusions, we're seeing more of them, greater use of them. We're seeing the deadlines that are specified at the beginning of the project. We're seeing, even if they're aspirational, the exercise of setting a deadline and holding agencies to it is key. And if there's slippage, there's always slippage, but better than that, to have no sense at the beginning of the project how long this is going to take. Congress has gone so far as to authorize the Department of Transportation to penalize its sister agencies when they don't comply with schedules. They did this. And then the latest is something called the FAST Act, which is the latest transportation authorization bill that has new tools for accountability. An interagency permit review task force, as well as something called the dashboard, where projects are being put up online, and you can see, what the schedule is and how the agency is adhering to the schedule that it's set. I mean, you can see this, when UPS sends you a package, why can't you do it for federal permitting? And so that's sort of the technological fixes that we're seeing here. I'm going to skip this in depth, but some of the hot topics we've hit under NEPA are one, greenhouse gas emissions. You probably saw the executive order that rescinded guidance that was issued by CEQ years in the making about how agencies should consider climate change and doing their environmental reviews. That guidance was rescinded by executive order, and the agencies are now in the process of getting rid of everything that depended on that guidance. But make no mistake about it, greenhouse gas emissions are a necessary component of NEPA analysis. They always have been, and they will be. Why? Because courts. I mean, if you take it to, if you do not have a climate change analysis in your NEPA document, the court, you're exposing yourself to significant litigation risk. Another thing I want to talk about just very quickly is NEPA assignment. So states, this big theme of this administration, states can do it better than the feds. Well, the last couple of administrations have agreed, and they started with a pilot program in California. It's now expanded to 5 or 6 states, where states have taken over for transportation projects, and so far I think only for highway projects, the role of the federal government in doing the NEPA review. They are doing the federal NEPA review, and they are doing the federal permitting, environmental permitting for their projects. And so we've worked with a couple of states, Florida most recently, that's taken on this role. And what's the point, right? The point is that the state agencies knows their resources and their projects better than Washington does. They know the players, they know the field offices for the agencies, and they know the stakeholders better because they're on the ground. And so there have been documented time savings through NEPA assignment. I think other states are interested in looking at this in the pipeline. I'm going to skip this, but you don't always have to do heavy, brand new NEPA for every project. Look around, see what's been done before. There's an exercise called keyring where a programmatic decision has been made with NEPA and anticipated, site-by-site decisions that also trigger NEPA. Well, some of those have been considered at the programmatic level. You don't need to redo that work. You just need to ensure that it's still valid and you can adopt it or incorporate it by reference. Again, new things that are setting, some of the hot topics, defining the scope of the project. How are we going to cope with fewer agency staff? You see the president's budget cutting out the large percentage of the number of agencies. If there's not people sitting at their desk and they have more projects coming in, how are we going to get these out the door quickly enough? Again, talking about ways to supplement staff and to make sure that you're getting the most of your interactions with the agencies. Again, public-private partnerships, that's another issue for NEPA. Private entities, how do they pertain to the NEPA process? And then last thing I'll say is just sort of this latest thing for deregulatory actions, this 2-for-1 guidance, right? There's a stress that we're going to cut out regulations that are too burdensome. Well, you can't just cut a regulation, you have to issue a new regulation. Each of those regulations require NEPA, right? So how are we doing sufficient NEPA on those types of considerations and those types of actions to make sure that we're not just, that deregulatory actions are just going to get sued and, routinely overturned when it's inevitably challenged in court. So summary slide, NEPA procedural, it's not substantive. Build your administrative record because that's to be the basis that you're going to be evaluated on if you get sued. Look each time what's been done before, but make sure that your NEPA analysis is sufficiently project specific. Don't hide your gaps. There's going to be an issue with every project. It's not going to be perfect. It's not going to save the environment. There are impacts from every project that you have. Acknowledge those impacts and acknowledge the issues and answer the comments that you get. Don't ignore them, because if you answer the comments and someone disagrees with you, the court's going to defer to you as the agency. And last, keep following these efforts because it's a kind of the ground's changing under our feet a bit to determine what's going on to make these faster and more efficacious. So I think I'm a little bit over my time, but let me kick it over to Jane to talk about a very non-procedural environmental statute called the Endangered Species Act.
Great, thank you. I get the clicker now. Great. So one of the things I like about both NEPA and the ESA is that compared to these behemoth statutes like the Clean Air Act or the Clean Water Act, they're both really short and sweet. I mean, you can sit down and you can read. I mean, NEPA is like this long, and the ESA is only like 11 sections. So they're very powerful statutes, but the good thing is they don't take a month and a PhD to get through them. So I'm going to talk about the Endangered Species Act, and like Jamie said, this was a creature of the early 70s, a time I think we will never see again, when both Democrats and Republicans were doing a race to the top in environmental issues as opposed to a race to the bottom. And even though it's now almost as old as I am, it was enacted in 1973. The need for it and the need for endangered species protection is greater than ever. We are now in what many biologists are calling the 6th great age of extinction. I mean, this is comparable to when, dinosaurs vanished off the earth, because our extinction rates of species globally is now at about 1,000 to 10,000 times the natural background rate where species go extinct for natural reasons as opposed to anthropogenic reasons. The IUCN, the International Union for the Conservation of Nature, is basically a global hard look at what species we know about in the world and what the risks to those species may be. The red list is only assessed about 5% of all species known to science, and it's amazing but true, there are still many species, unknown to science. And with respect to this small fraction of described species, something like 26% of all mammal species are vulnerable, threatened, or endangered. 41% of amphibians, 33% of reef-forming coral species, a third of all shark and ray species, 13% of bird species. And if you think about it compared to the diversity of species we have on Earth and the rate at which we're losing them, it's really mind-boggling. So the World Wildlife Federation has done an estimate of individual animals. How many vertebrates, individual elephants, frogs, fish, whatever, have we lost? And just over the 40-year period from 1970 to 2010, which is a time period in which I would estimate most of you have been alive, the absolute numbers of vertebrates have declined almost 40% for terrestrial species, more than 75% for freshwater species of fish, amphibians, etc., and almost 40% for marine species. A more recent report on marine report, which is something that I have a particular interest in. Again, we've seen almost a halving of the population of fish, marine species, including reptiles such as sea turtles, including mammals, marine mammals. And if you think about the, not only the biological importance, but the economic importance that these species have to humans, you think about how rapidly human populations are growing and how much fish populations are shrinking. This is not simply a question of biologists and labs sounding an alarm. It's also, an enormous economic and, human health impacts year-round. I just read a newspaper article that the latest bleaching cycle, where coral reefs are stressed by warmer water temperatures, such as they get rid of their resident algae. We've just ended a massive 3-year bleaching cycle, but it's really scary. If you look at what's maybe the likely outcome of warming oceans, we may we've already lost half of all coral in the world, and we may lose the rest by 2050. So if you've thought about getting certified to become a scuba diver and go see coral reefs, I advise doing that sooner rather than later, because they may not be around. There's a lot of fish that are almost to the point of extinction. For example, Pacific bluefin tuna, if you've ever seen pictures of the Tsukiji fish market in Tokyo, where one of these enormous fish can go for tens of thousands of dollars. They're at less than 3% of their unfished numbers, and most of the fish that are left are juveniles. So, when you look at your sushi in a sushi restaurant or the fish market in Japan, just know that that's not a resource that's likely to be around for much longer. So. With that depressing introduction out of the way, we're going to talk about what the 43-year-old Endangered Species Act is all about, and there's going to be a lot of resonance with what Jamie has discussed with NEPA. The ESA came about 3 years after NEPA was enacted, and a lot of the concepts in NEPA are you'll see reflections of them in the ESA. Although, as Jamie has mentioned, it is a statute with substantive requirements in addition to procedural requirements. So, in some ways, this is a very forward-thinking statute. The statute was enacted not only to provide a means for conserving individual listed species, but to conserve the environment, the ecosystems on which they depend. There's a recognition that you can't preserve species in zoos. They have to be conserved in their living environment. And it's also very forward-looking because it's not just about taking Martha, the last passenger pigeon, and keeping her in the zoo. It's about conserving endangered and threatened species, which means as we see on the next slide with conserve and conservation, it's not enough just to keep them from going extinct. You have to take steps to bring them back to the point at which the protections of the ESA are no longer required. And another overarching theme of the Endangered Species Act, it is not just a statute that is administered by, particular agencies. It's directly administered by both the Fish and Wildlife Service and the National Marine Fisheries Service, which is an agency within the Department of Commerce, depending on the species. But the ESA imposes obligations on all federal agencies. So this statute was one in which Congress tasked the entire federal government with the responsibility for conserving, i.e. bringing to the point of delisting listed species and using their non-ESA authorities in pursuit of that goal. So we're going to talk about some of the major sections of the ESA. Again, like I said, it's a short and sweet statute. I'm not going to hit everything, but we're going to hit the big ticket items. And we are going to start with, how does a species make it to the statute in the first place? So it's listed under Section 4 of the ESA. There's a couple key terms to be aware of in here. Congress, through various amendment processes in the 70s, distinguished between endangered species, which are in danger of extinction throughout all or a significant portion of their range, or threatened species, which has more of a foreseeability element. It's not in danger right now, but we can foresee in the future it's likely to become an endangered species throughout all or a significant portion of its range. So the process by which species are listed as endangered or threatened may originate either with the agency, either Fish and Wildlife Service or NIMS may on its own initiative begin the listing process when they've identified a species that needs to be considered for listing, or a member of the public, an organization such as my own, an individual citizen, or an interest group of any kind may begin the petition process. And as a side note here, the petition process can be used for listing or downlisting from endangered to threatened, or delisting to take the species off the list altogether. And this is something in recent years we have seen a lot of activity from groups that have petitioned the government to downlist or delist species. The Fish and Wildlife Service very recently downlisted the West Indian manatee from endangered to threatened, and that petition process had originated with a group of Save Crystal River, which is an interest group in Florida, represented by the Pacific Law Foundation. So, it's an open process. Any member of the public can kick off this process. And there's, much like the EIS process, there's stages and deadlines that the listing agency has to undertake. First, it has to make a 90-day finding on the petition, which is basically, would a reasonable person think that the petition to action is warranted? But the agency doesn't do a whole bunch of research for this. It doesn't go out and start searching the literature. It says, what's in the petition, what's in our files that we already know about, and then either it goes to the next step or we don't think it's warranted and it stops here. So that is supposed to be done within 90 days to the maximum extent feasible of receiving the petition. So it's not meant to be, a hugely time-consuming finding. And if the petition passes that hurdle, then within 12 months of receipt of the petition, the agency initiates a status review. And that's when it does go to the scientific literature. It looks for all the available information on the species to say, does it warrant listing? And if it doesn't, then it publishes a negative 12-month finding and the process is over. But if it does find that the species warrants listing, it publishes a proposed rule to list it as endangered or threatened, puts it in the Federal Register for public comment, and then moves forward. And then within 12 months after that, there's supposed to be a final determination. And again, we can finalize the rule, or we can say, never mind, we've decided to withdraw the proposed rule for various reasons. Maybe we found more information, maybe there's been some conservation commitments on the part of private parties or state agencies to conserve the species such that we think that conservation will be adequate to prevent the need for listing. So the statute is very specific about what factors are and are not considered in a listing decision. One, of course, is habitat. That is a major reason that many species warrant listing, because their habitat has been destroyed, adversely affected, curtailed. Another is overutilization. So, for example, if you think about fishing, there are a number of sturgeon species, the big 6-foot dinosaur fish, that have been listed on the Endangered Species Act. One called the Atlantic sturgeon. There used to be, 100 years ago, huge cannery operations on the Delaware River, because when they spawn in freshwater, they migrate out to the sea, then they go back to freshwater to spawn, and there was a huge cannery industry catching those female sturgeon for their roe, basically caviar. I mean, it used to be to the point where you could just go out in your boat and they would jump into your boat almost. And now there's only a handful that return. And the major reason that the sturgeon were massively killed off by the cannery industry, kind of a tragedy of the commons. There was no regulation to the point where they've now been listed. Species can be listed by disease or predation. Those are natural factors. Humans don't have control over those, but yet it is still a listing factor. And a major example that you may have heard of is cave-dwelling bats in North America have been absolutely decimated by a non-native fungus called white nose syndrome that's caused population declines of up to 99% of some of these bats. So recently, the northern long-eared bat was listed as threatened. Now that it's been, reduced to a tiny fraction of its population, there's essentially additional additive effects of habitat loss and so forth. But the major factor behind its listing was disease, and that listing occurred notwithstanding that humans have not targeted the species directly. Factor D, inadequacy of existing regulatory mechanisms. This is where the agency has to take a look and say, are there state protections in place? So this species, are there any state or international or local regulatory mechanisms that might provide adequate protection for the species? So this is a legal analysis as opposed to a biological analysis. And then E, other natural or man-made factors. That's the catch-all for everything else. So the agency, in making its decision, can list on the basis of any one factor or any combination of factors. So you don't have to have two or more, you can have just one, but the agency does have to look at all five. On the mitigation front, if you will, it has to take into account the efforts of state and foreign governments. Foreign governments is in there because species can be listed as endangered or threatened no matter where in the world they occur. They don't ever have to, show up in the United States as part of their range. And there are actually a large number of species that are entirely either in the high seas or within the jurisdiction of foreign governments that nonetheless have been listed on the ESA. A really important component of the listing decision is that it explicitly must be made solely on the basis of the best scientific and commercial data available. And by commercial, the statute's referring to stuff like fish catch data, not economic factors. So the statute is very explicit that the economic impacts of a listing decision may not come into play. We cannot decide this species should not be listed because the economic costs of it, would outweigh the benefits to the public of listing. So that is something where the agency has to be very careful not to let the concerns of potentially affected industries play into the listing decision. Section 4D, I'll mention here. We're going to talk about the prohibitions of the statute in just a minute, but the distinction between endangered and threatened is very important because by default, endangered species get all the protections of the statute, and threatened species get none of the protections of the statute unless the Secretary of Interior or Commerce decides that the species needs some or all of those protections. So we will go on to critical habitat,
but it is illegal to take a threatened species because they're determined, right? That
not necessarily. So so the two agencies, Fish and Wildlife Service and National Marine Fisheries Service, generally they march in lockstep. They do regulations together. They do guidance, policy documents together. But interestingly, once upon a time, Fish and Wildlife Service promulgated what's called the general 4D rule, which is basically default.
Right.
By default, all threatened species will get all the protections
right.
of the Endangered Species Act. NIMS never did that.
Right.
So under the National Marine Fisheries Services rules, no threatened species gets any protections of the statute unless the agency promulgates a special 4D rule, and then they can pick and choose.
Yeah.
They could say, you know, which protections
right.
apply. So we have seen a trend more recently with the Fish and Wildlife Service being much more active in tailoring 4D rules
yep.
to particular species, as opposed to letting them all fall under that default rule. So at the same time that an agency lists a species as endangered or threatened, it is also meant to designate what's called critical habitat. So that can be either the area where the species currently exists and that habitat is occupied by the species. It can also be unoccupied. Maybe the species once occurred there, but now it has shrunk back. But whether it's occupied or unoccupied, it has to be essential to the conservation, i.e. the survival and recovery of the species. The habitat also has to require special management considerations or protections, and there are outs for the agency not to designate critical habitat. So it may be not prudent to designate critical habitat, for example, if you're talking about a plant or a butterfly, and people might want to go collect the last one. So you don't actually want to draw an area on the map where they exist, because then you're pointing collectors or other people who may have nefarious purposes toward that species. Right,
yeah.
Exactly. You can also figure that critical habitat is not currently determinable. We know that critical habitat may be a good idea, we just don't know enough about the critter's habitat needs to figure it out, so we'll give ourselves an extra year. So I've said species can be listed anywhere in the whole world. Critical habitat, however, can only be designated within areas that are subject to U.S. jurisdiction. And that's because, as we'll talk about in a minute, critical habitat protection only comes into play in the obligations that are put on federal agencies when they're consulting on the impacts of their actions. So if we don't have a species, at least in part within the United States, then critical habitat does not get designated. Section 4 also requires the agency to put together a recovery plan. So this plan needs to include metrics. How will we know, for example, with an endangered species, when it will be ready to downlist it to threatened? How will we know when it's threatened, when it will be ready to delist altogether? And it puts together actions that should be taken to promote the recovery of the species. It's a binding obligation on the agency to do recovery plans in almost all instances. Again, we don't do them for species entirely outside the U.S. However, the recovery plan itself is not a binding document. It's more of an aspirational document. It's a roadmap, but it doesn't actually impose obligations either on federal agencies or private parties. Every 5 years, the agencies are supposed to take a look at the species in the status review and say, what do we know about it? What's the latest and greatest? And that process may lead to a downlisting, a delisting, or possibly an uplisting. If it's gotten worse, we can uplist from threatened to endangered.
So let me ask you a question. What happens when the agency doesn't reach its 12-month finding within 12 months?
Oh, well, then, so the deadlines that the statute sets are mandatory, non-discretionary duties. The agency must hit those marks, although there's wiggle room in the 90-day if they're super busy and jammed or they just can't get it done. But at the 12-month stage and the 24-month stage, those are mandatory shall means shall deadlines. And if the agency misses the boat on those deadlines, then as we'll talk about with the enforcement of the statute, citizens, anybody, can bring a missed deadline suit. And
they've never missed a deadline.
they miss deadlines all the time.
Missed a lot of deadlines.
So you know, and when a deadline suit is brought, it could be an environmental group, it could be a private citizen, it could be a group in the manatee case that I mentioned, the Pacific Law Foundation, on behalf of its clients, brought suit when the Fish and Wildlife Service missed those deadlines. And that's the kind of, you know, since the agency is pretty much always going to lose that case, it usually results in a settlement agreement to say, okay, we know we missed it, you know, here's when we're going to get it out. So, you know, those deadlines are something that the agency really should try to meet. Otherwise, it's very vulnerable to litigation. So let's talk about Section 9, which is the, what's called the take prohibition. This is really the teeth of the act, and it's very broadly written. The take prohibitions of the statute apply to any person subject to the jurisdiction of the United States. So that could be a federal agency. That could be a state agency to the extent permitted by the 11th Amendment. It could be a private corporation. It could be a private individual. If you are subject to the jurisdiction of the United States, you are subject to the take prohibitions, which are very broadly defined as harass, harm, hunt, shoot, wound, kill, trap, capture, kill, collect, or attempt to engage in any such activity. So the important thing to know about this take definition, you know, for those of you who are lawyers, is there's no scienter requirement. It doesn't have to be intentional take. It can be intentional take. If you go out because you want to shoot a grizzly bear and you shoot a grizzly bear, you know, you're liable under Section 9. If you go out and build a shopping mall on top of a wetlands that has some endangered critter in it, and you haven't gotten your permit from the service, then you are liable for that take. So that can be what's called incidental take. Right. Your activity is otherwise lawful, but your take that happened as a result was incidental to your otherwise lawful activity. Without a permit, you are on the hook for that take. By regulation, harm includes habitat modification where it actually kills or injures wildlife. See, it doesn't have to be necessarily a dead body on the ground at this exact minute, but if you're going out and you're cutting the nesting trees and, you know, the animals can't nest successfully, or, you know, you're otherwise you know, interfering with their natural life functions, you can be liable for that. And there's civil and criminal penalties. I mean, this statute is really not kidding around. In terms of penalties, obviously, only the federal government can enforce those, but we will talk about in a minute the private enforcement mechanism through the citizen suit provision of the ESA.
And that's where scienter can come in. I mean, in terms of your penalties shoot up
yes,
when you get
yes,
the criminal.
Right.
You try.
Yes,
yes,
that's right.
Yes.
That's right. So let's talk about Section 7, because like NEPA, the ESA applies to all federal agencies, except in some limited circumstances. The heart of the ESA is really Section 72, which is both the substantive and procedural obligation to ensure that actions authorized, funded, or carried out by the agencies do not jeopardize the continued existence of a listed species or result in the destruction or adverse modification of critical habitat. So Section 72, starting with the critical habitat part first, this is the only place where critical habitat makes a difference. If you're a private party and you don't have any federal nexus that would require a federal agency to give you a permit, and you go ahead and you like knock down the trees that are designated as critical habitat for a listed species, or, you know, let's say it's unoccupied critical habitat, so we don't have the issue of direct take. But, you know, the federal government has said in the future the marbled murrelet needs this habitat to expand into, to recover. It's not there right now. You knock it down, no harm, no foul. However, federal agencies have to consider in any action over which they have discretion whether they are going to jeopardize listed species or destroy critical habitat. 71 is interesting because it harks back to the purpose of the statute, which is to ensure that all federal agencies, doesn't matter which one it is, whatever their authorities are, their enabling statutes, they are required to do good things for listed species. The courts have found they have discretion. Like, plaintiffs can't come to court and say, you haven't done X, Y, or Z specific actions. As long as they're doing something for some listed species using their existing authorities, they're okay under 71. But it does show how broadly the ESA was drafted to require federal agencies who otherwise have nothing to do with wildlife to use those authorities. So probably the high watermark of ESA litigation, and a high watermark that the courts have been backing down from ever since, was the seminal case of Tennessee Valley Authority versus Hill back in 1978. And this is actually a case where, basically, as part of a benefit, creating a power plant for Boeing, which was going to build some sort of manufacturing facility here. The Tennessee Valley Authority was going to build a dam and thereby destroying the last remaining habitat for this little tiny, insignificant 2-inch fish called the snail darter. This went all the way up to the Supreme Court, and the Supreme Court basically, shocked Congress when it said, by the way, Congress, what you did was so clear that, because the TVA is going to cause the extinction of the species when it, shuts the last gates on the dam, no means no. That means you're going to jeopardize the survival of the species, and the project has to stop. Because when you enacted the ESA, you enacted this conscious decision to give endangered species priority even over the primary mission of an agency like TVA, which its mission was to, manage waterways to create power. So this is actually a pretty big shock to many in Congress, that we've got, this tiny 2 or 3 inch fish, and, Congress has already appropriated and spent hundreds of millions of dollars on this project, but that's exactly what you did in enacting the ESA, and so we are going to, say that no means no. You can't jeopardize this species. Of course, devil in the details from in subsequent litigation. Jeopardy is not something that's either found often by the agencies or no jeopardy decisions are not as frequently reversed by the courts. So, there's standards for in both regulation and a case law for what do we mean by jeopardy, and what we mean is an appreciable reduction, some kind of measurable reduction in the likelihood of both survival and recovery of species in the wild. And by destruction or adverse modification, we mean an appreciable, like a measurable or otherwise analyzable diminution in the value of that habitat for conservation, i.e. survival and recovery. So these are pretty big sticks. These are something that agencies ignore at their peril. So what they have to do to get out from under the possibility of a jeopardy opinion or a jeopardy situation in Section 72, they have to comply with the duty to insure against jeopardy, and the way they do it is by following the consultation process, which we'll talk about in just a second. Sort of echoing NEPA, the rule is, as in NEPA, the federal agency has to have discretion over whatever the action is. If the agency has no discretion, then it doesn't have to consult. And an example here in this National Home Builders case was under the Clean Water Act, the EPA can delegate the authority to administer the NIPD's discharge permitting program to the states. States come in and apply, and if they hit the checklist that's set by the statute and EPA finds they will adequately administer the statute, EPA delegates that authority to the states. And in this case, the Supreme Court found that because there's that checklist, and as long as EPA checks all the boxes, it has to delegate the authority to the states. It has no obligation to consult under the ESA because it can't condition its approval of that delegation on you must do these good things for species. But in any instance, like NEPA, if you are issuing a permit, if you're funding, like through a highway project, if you've got any kind of approval, you have to consult. And again, sort of echoing NEPA's broad look, not only at the immediately affected area, but downstream affected area, you have to look at the areas both right on your site and indirect effects. So if you're dredging and filling through a stream as a result of coal mining, and you're going to have pollutants that are released from that mining process and they wash downstream, you have to look at the effects on those downstream critters as well. Consultation, again, this theme that, you know, federal agencies can only do what they can do within the United States. We don't have to consult on projects that are, you know, totally outside of the United States because there's sovereignty concerns there. And, you know, a seminal case on that is Defenders of Wildlife versus Lujan. You know, if the federal government is helping to build a dam in Egypt, it doesn't have to, you know, consult on what the effects on potentially endangered species might be. So this is the process by which federal agencies satisfy their substantive obligations. And again, you know, being repetitive here and echoing NEPA, it's much like the categorical exclusion EIS process. There's various off-ramps where, you know, if it's a minor effect or you know, there's no effect, and the agency, the action agency, determines that, then the project can go forward. They don't even have to talk to the service about it. But they do have to take a look at it, and they do have to, you know, document it for their files that whatever the project is not going to have an effect on species. So you know, the next decision point, if it may affect, and again, like NEPA, this can be positive or negative effects, they have to go talk to the service in what's called an informal consultation process. And all that means is, informal means it could be telephone, letter, email, whatever the communication is, just getting to a meeting of the minds with the service about whether the effects are going to be fairly minor. And so if they come up with this may affect, not likely to adversely affect, the service says, yes, 2 thumbs up, we concur, you're done. You don't have to go any further. The service issues a written not likely to adversely affect finding, and you go forward. If the service says, no, we don't agree, or the agency on its own initiative says, yes, this project is likely to adversely affect the species, then you're going to the formal consultation process. And in that process, both the action agency and the service have obligations that are spelled out by regulation, including, you know, show your work in a written document, the biological assessment, and on the wildlife agency's part, the biological opinion, you know, what are the effects on species going to be? Like NEPA, we have to consider the baseline. Everything that's happened up into this point that has put the critter where it is. We have to look at direct, indirect, and interrelated effects of the action. And we have to look at cumulative effects, which are basically the impacts of private projects that are not federal projects that are going to have their own consultation down the road. As in the listing process, you have to use the best available scientific and commercial data. So that's explicit in the statute and the regulations. So there's basically 2 ways that consultation can go. We can go to no jeopardy and no destruction or adverse modification of critical habitat, and then the agency gets an incidental take statement, which is its get out of jail free card for you know, the potential penalties of Section 9. And if it's the federal agency, for example, the Army Corps is doing a 404 permit for a private project proponent, the proponent of the project gets the benefit, gets the coverage of that incidental take statement as well. And the take statement is supposed to be, you know, here's how much you get. You know, either you get like a specific number of animals, or if we can't really figure that out, we have to have some sort of reasonable proxy, like, you know, a certain number of acreage of habitat affected. Even if we can't find the dead bodies, we know that if we get to this certain amount, you know, that's what's been permitted. If we go above that, we have to start the consultation process again. There need to be, you have to minimize and mitigate the impact of your incidental take. You have to, the terms and conditions to implement these measures, you have to have reporting so that the service knows what's going on. It's not just, you know, go forth and destroy habitat and never check in with us again. And you have to reinitiate consultation if new information or your take limits are exceeded. So as long as there's ongoing federal involvement, discretionary involvement, such as, for example, the Bureau of Reclamation administering water control projects, then as long as they have their fingers in that action and there's still something they could do to benefit species, they're under that ongoing obligation to avoid jeopardy and consult as necessary. So this does happen, and once in a blue moon, the service says, you know,
how often it happens?
yes, jeopardy, you know, do not stop, you know, do not pass go, do not collect $200. Like, you're closing the gates on the Tellico Dam is going to wipe out the snail darter. So what the Wildlife Agency will do is say, but here's how you could do it different. You could still accomplish the goals of your project, but here's your reasonable and prudent alternative to avoid jeopardy. One of the important concepts here is that the biological opinion is just that. It is an opinion from the Wildlife Agency. It is not actually binding on the federal agency. The federal agency has a choice when it gets back the biological opinion, whether it's jeopardy or no jeopardy. We can do what the biological opinion says, and we can get coverage with the incidental take statement. We could modify the project to do something differently. Maybe, you know, whatever the RPA or RPMs are just aren't going to work for us. So let's figure out how we can modify it so we can get to a result we like. We can abandon the project, or if we really like to live dangerously, we can go ahead and do what we want without following the RPMs or RPAs. And sort of the ultimate out is a committee that was set up after Congress realized what it had done after the Supreme Court's decision in TVA v. Hill. We can go to the God Squad. And the God Squad is 7 cabinet level members who can decide, you know, yep, it's worth it to us as a country to shut the gates on the Tellico Dam and wipe out the snail darter because, you know, our investment is more important than the 3-inch fish. So even though it's the ultimate out, it's only ever been convened 3 times. So it's, you know, and I don't expect it to see it.
Or you give the epilogue on the TVA project?
Oh, it was, they did it. They shut the gates, and then they found the snail darter somewhere else later.
Yeah,
so,
Congress overruled it.
Right.
So.
And then Boeing pulled out and never built the plant.
Right.
So there you go. So as with NEPA and categorical exclusions, the numbers of informal consultations far, far, far outweigh the numbers of formal consultations. So usually the agencies are getting together and working it out. It may be, you know, let's figure out how the project could be reconfigured to avoid impacts, you know, much like a mitigated FONSI, except with much less paper covering that. But you know, even though there's a lot of hay made about, oh my God, you know, biological opinions that take so much time and they're so expensive, those are really much less of the time that the agencies spend on consultations. And, you know, it's also true that the ESA may add process to whatever the, you know, development process of a project or a permit is. But in the vast, vast, vast majority of cases, project proponents, federal agencies get to do what they want because biological opinions will try to, the agencies will try to work it out so they can get to a biological opinion that's a no jeopardy opinion that's got reasonable mitigation requirements, you know, so whether it's reconfiguring the project, whether it's figuring out how we can make it work with these reasonable protections, you know, most projects, at least from Fish and Wildlife Service since 2008, which is the data that we've looked at, do not get halted by the ESA. And 2 of my colleagues from Defenders looked at every single consultation that the Fish and Wildlife Service did between 1979 and 2015, and this is what they found. And you can also see, if you look at that lowest line, that the number of jeopardy determinations has gone, you know, precipitously downhill. So it certainly may have been the case once upon a time that the agencies issued jeopardy opinions, but that has certainly not been true in recent years. And, you know, it doesn't necessarily have to be because the agencies have rolled over and given up. A lot of it can be that, whatever the case, that the agencies figure out how to make the project work without reaching that, no-go stage of jeopardy.
Can I just use a practice pointer? So you guys saw at the beginning on that flow chart, the first thing is no effect, right? And if there's no effect, the agency can determine no effect, that you don't have to do any concurrence. Sometimes you get a concurrence letter from FISH, but often you don't. As a practice pointer, we often tell our clients to get there if you possibly can, and there's work to get there. I mean, there's upfront investment, rerouting your project, but doing what you can to get to no effect, because while ESA will not stop your project, at the end of the day, it can slow you down significantly, and delay can mean death for a project. It takes. I mean, how long in your experience does an informal consultation typically take?
There's no deadlines, and there's no sort of set process. And the other interesting thing about the consultation process, as opposed to the NEPA process, is that it's not a public process. The agency doesn't publish a notice that it's in informal or formal consultation. There's no public comment. So sometimes it's a black box. The agencies may be talking amongst themselves, but we don't know when they started talking, or how long it's taken. But certainly, I would agree with your advice to your clients. The upfront work. Do we have an endangered species here in the first place? Is there a way that we can redesign whatever the project is to avoid those potential impacts? And then, can we educate the federal agency so that it does its job in informal consultation, or in the no effect stage of documenting that work? Because a big area where agencies fall down on the job and then open themselves up to litigation, and then open projects and permits up to delay, is when they don't show their work, and they don't have it written down. If you're a project proponent and there is no federal nexus, there's no Clean Water Act 404, there's no Clean Water Act NIPD's discharge permit, there's no federal nexus whatsoever, you can still get an incidental take permit from the wildlife agency to permit your incidental take. And so it's comparable in some ways, but there's additional requirements, such as you have to do a habitat conservation plan. Like, we're going to take the species here, but here's how we're going to minimize and mitigate and offset the impacts. This is an area where maybe you're going to destroy this particular area, but then you're going to do 2-for-1 mitigation, and you're going to buy land in a conservation bank, or buy those credits, and then that area is going to be protected in perpetuity. So there's a lot more play in Section 10 in how to shape a particular project and the mitigation for that project to hopefully result at least in sort of no net loss of the species, or even benefit to the species, because maybe you're destroying some pretty marginal, degraded, fragmented habitat over here, but you're going to contribute the dollars so that over there there's higher quality habitat protected. So a Section 10 permit itself is a federal action, right? So the Fish and Wildlife Service, in approving a Section 10 permit, has to do NEPA, and it has to do a self-consultation. So depending on the action, Fish and Wildlife Service and NIMS can be both action agencies and wildlife agencies, so they have to do a consultation with themselves. And Fish and Wildlife Service as a land management agency, because it administers national wildlife refuges, and National Marine Fisheries Service as a resource agency, because it administers the Magnuson-Stevens Fisheries Act. They often have to do these self-consultations with each other. And in the case of an incidental take permit, the Fish and Wildlife Service has to do its own internal work to make sure that approving this permit will not trigger the jeopardy standard.
That's a question. Has the Fish and Wildlife made that determination it needs to self-consult, or has it been told by anybody that it needs to do self-consultation?
I think they've just always done it as a matter of course. I mean, because they too are subject to Section 7. So if they have a permit, or for example, if Fish and Wildlife Service is promulgating regulations governing hunting,
regulations,
a refuge, right. But this is a permit. They're issuing a permit, so they have to ensure that this permit does not itself jeopardize species, and that's certainly been litigated
Mm-hmm.
when their consultation has been alleged to be
Mm-hmm.
inadequate. But they don't have, you know, unlike say EPA, which has the functional equivalence, we don't have to do NEPA because we really already do NEPA.
Right.
You know, the wildlife agencies do enough different things that there's no functional equivalence doctrine under the ESA. So moving on to judicial review, like I mentioned earlier, oh, I got a backwards bracket. Like I mentioned earlier, the citizen suit provision of the ESA is really broad. So any person can commence a civil suit to get injunctive relief, i.e. stop a project or halt a project during the pendency of litigation, and can get that injunction against a federal agency, against a state agency, as long as you've got your 11th Amendment ducks in a row, or against a private party. So this is this injunctive relief, going to the court to get an injunction to halt a project that may take endangered species or threatened species without the appropriate Section 7 or Section 10 coverage, is a very powerful part of the citizen suit provision. So private citizens, of course, cannot sue the federal government to make the federal government enforce the act. So if there's a take situation, like for past take, where civil or criminal penalties might apply, private citizens can't go to the Fish and Wildlife Service and say, you must go enforce. You know, the federal government always has that discretionary authority to decide whether to pursue civil or criminal penalties. But, you know, private parties do have that ability to get injunctions, so the court can figure out, you know, do you have like a reasonably foreseeable likelihood of take? Has that take not been appropriately permitted? And we're going to halt the project until that take has been appropriately permitted. And as Jamie was talking about earlier, if you have a mandatory non-discretionary duty, a 90-day deadline, a 12-month deadline, a 24-month deadline, citizens can sue to get a court order forcing the agency to do the required action by a certain date. Of course, the agency is still free to make whatever decision it's going to make. The court cannot say you must list the species by X date, but it can say you must make the final listing determination by X date. So there's the citizen suit provisions, but the Supreme Court has found that there's also a cause of action or causes of action against the agencies such as the Fish and Wildlife Service or NIMS when they're administering the statute. So if you're going to sue the action agency because you think that its action is going to be taken in violation of its mandatory duty to insure against jeopardy, that's a Section 7 case. But if there's a biological opinion and you're saying it's a bad biop, you didn't consider the best available information, and you're suing the Fish and Wildlife Service for that biop, that's not an ESA citizen suit provision. That is an APA cause of action. And you know, as with most of our federal decision making, the APA, also a nice short and sweet statute, doesn't take long to read, but very important. It supplies the standard of review, which is what you would expect. The agency's decision is going to be upheld unless it was arbitrary and capricious, not taken based on the available information, or undertaken without compliance with the law. I'll just go very briefly over this. The ESA is also a really important statute because it implements many of the U.S. government's international commitments to conserve endangered species. So, most treaties are not self-enacting, basically self-implementing. Like the U.S. government has to take an affirmative step to take its obligations that it's signed on to in the international treaty context and make those into U.S. law. So this is what Section 8 and 8A are all about. Section 8 enables the U.S. government to assist other countries in conservation of species, and Section 8A implements two very important conventions, CITES and the Convention on Nature Protection and Wildlife Preservation in the Western Hemisphere, the Western Convention. So this provides the domestic source of authority for U.S. agencies to implement our obligations under these treaties. And the most important aspect of this is trade in wildlife. So under CITES, at the international level, the countries that are party to CITES can vote to put species of animals or plants on what's called Appendix 1 and Appendix 2 of CITES. And it doesn't, under Appendix 2, which is the bigger one, it doesn't ban trade, but it just says you have to ensure that whatever that trade is going to be sustainable. So on the exporting country side, you know, there has to be a permit that says the scientific authority has looked at it and this is not going to wipe out the species. And on the importing side as well, the U.S. government has to do the same thing. And you know, wildlife is a huge market. I mean, you know, and plant products as well. You know, there's a lot of tree products like lumber that are traded that are affected by CITES. You know, there's the pet market, sort of the captive animal market, the animal product market. You know, a big thing that we import from Latin America is cowboy boots made out of the skins of rays and things like that. Obviously, food products. There's all sorts of stuff that's in legal trade, and illegal wildlife trade is, I believe, second only to like the drug trade in terms of profitability, which of course CITES isn't going to regulate, but legal trade can be cover for illegal trade. And the U.S. is a huge market for both illegal and legally traded wildlife products. And the ESA prohibits commerce in enlisted species unless there's a permit. So even though our take prohibitions don't apply in other countries, we can't enforce against take that occurs entirely outside our borders. If those products come into the United States, like say you want to import your tiger skin or something like that, then the ESA is going to kick in to prohibit that unless there's a permit. So the big question is, and this is a very timely question, has the Endangered Species Act worked? And by and large, the answer is yes. There's had been very, very few failure stories where a species has been listed under the ESA and thereafter it's avoided extinction. So, and some of our iconic species have recovered really from the literal brink of extinction under the ESA. However, this has been a hot topic in Congress for a number of years, and especially in the past several years, we're seeing more and more legislative attacks against the ESA. Some of them are under the guise of, modernization, we need to improve the ESA. Some of them can be like species specific, like we're introducing a bill that will not allow the service to list a particular species. There's just a huge number of bills, and my organization has been charting these over the last two sessions, and those are available on our website. We believe that the problem is not that the ESA itself is broken, but that it's starving. There's so little money directed to the wildlife agencies under the federal appropriations process for implementing the Endangered Species Act, whether it's on the listing side, whether it's on the recovery side, the protection side, and there's so many like specific line items that direct the agencies to spend their money. Like for example, salmon in the Northwest, they get the lion's share of the money, and there's many species that get $0 in a year for recovery. But then of course, critics of the act say, well, it's broken because species aren't recovered. But in 2016, Fish and Wildlife Service had, for its entire ESA program, including listing, including recovery, including consultations, all of it, was $234 million, which was less than 15% of the $2.2 billion in annual subsidies that the federal government gives to oil and gas companies to extract fossil fuels on public lands. So, we don't think the ESA is broken. We think it needs to be funded because when species do get adequate federal resources, they can recover. So, we're extremely concerned about the legislative attacks. Also, given the administration we're in, it was just announced that Interior Secretary Zinke is moving to reduce the staff of all of Interior by 4,000 people. Now, of course, not all those are going to come out of the Fish and Wildlife Service, but, if you don't have the staff to do the consultations, it's a problem. So just really quickly, I know we're almost out of time. In terms of things that are hot topics on the agenda, we see and are seeing more challenges from either regulated parties or states, for example. The top bullet is a case that's been fairly recently filed by a large number of states challenging regulations that were put out under the Obama administration to update the critical habitat regulations. Of course, a lot of these challenges can come from the side of the fence that I sit on at Defenders. The Obama administration put out a policy document interpreting significant portion of range, which, if you recall, is part of the definition of an endangered species or a threatened species, that it can be listed if it's endangered or threatened in a significant portion of range. And that has given rise to cases challenging the agency's application of that policy in various listing decisions. We're still seeing constitutional challenges to the ESA. Something like 68% of U.S.-only listed species reside in only one state. So there have been 7 circuit decisions so far from 6 different circuits addressing these various species pictured here, which are only found within the borders of one state, on Commerce Clause grounds. That, under the Constitution, because federal government is the government of, enumerated powers, we can only do things at the federal level if there's a constitutional basis. Because the Commerce Clause is the constitutional basis for the ESA, we can, regulate things at the federal level, like take of endangered species and listing, because there may be impacts on interstate commerce. Well, what do you have, like with the Utah prairie dog or the red wolf in North Carolina, or the Alabama sturgeon only in Alabama, if that species only occurs within one state? And so far, all the 6 circuits have been unanimous that the Commerce Clause does supply a sufficient basis for the ESA to be constitutional. But for example, right now, the 10th Circuit was the most recent circuit court to issue a decision, and the appellants in that case have applied for rehearing en banc. In other words, they want all the judges of the 10th Circuit to look at that.
The district court disagreed. So
well, the district court was an outlier there,
yeah,
so that was appealed and
right,
successfully reversed. But there's also a new district court case challenging the bone cave harvestman, which I believe is a kind of a spider. It's some invertebrate. So that apparently is an issue that apparently no matter how many times the circuit courts put a stake through the heart, it comes back. As with NEPA, climate change is a huge issue under the ESA. Climate change has to come into the analysis both for listing decisions. There are species that have been listed solely on the basis that climate change is going to cause them to become endangered in the foreseeable future. So the polar bear a number of years ago, more recently the Pacific bearded seal, they're doing fine now, but climate change is going to melt sea ice and is going to destroy their habitat. So that's been a big issue, both at the regulatory level and in the courts, and it also has to factor into consultations. And I think this is really interesting because, if you recall, the agencies have to make their decisions based on the best available scientific data. Well, before climate change was ever on the radar, it was like, well, let's look at what happened in the past. The past is a good guide to the future. Let's look at all of the data we've collected from past years. Well, climate change throws a spanner in that works. If you look at these 2 cases, which have to do with salmon in the rivers, you can't look at data from past decades of water management, because that's not going to hold true. The scenario that you might have predicted, I mean, it's like your investments. Past performance does not predict future results anymore. So NIMS at least has been forward-looking and put out a guidance document, like how do we consider climate change in our various ESA administration responsibilities. And it's only going to become a bigger issue. This is not one of our critters. This was a little, rat-like critter off of Australia, I believe, and it has gone extinct because the sea level rose and it's not there on its island anymore. But up to 1/6 of the planet's species are likely to be imperiled because of climate change. So, this is the challenge of the future with the Endangered Species Act as well as NEPA. So that's all we have, and I know that we don't have very much time, but I'm more than happy to stay for as long as anyone wants to ask questions.
Just one thing I want to, because I think you said, which is important, you know, the ESA is a unique federal statute in that it applies to private actions. And so, you know, often with the Clean Water Act or, you know, even NEPA, right? I mean, it applies to federal actions, federal agencies taking an action in lost federal lands. I mean, I want to build, you know, I want to build anything. I want to build something in my backyard, or build something in one farm, totally private lands. The ESA has the same take prohibition, and it's Fish and Wildlife that they're needing to for you to get coverage, or they'll give you coverage under the ESA is what will trigger NEPA in that case too. So it really is a nationwide applicable statute. And when you're going through like, what do I need to get? I mean, that you got to look for species no matter where you are in the country to make sure you're not.
And along the same line of, you know, we don't believe the ESA is broken, there has been a great deal of regulatory innovation over the years as the agencies have struggled with some of these problems. Like, for example, you have a well-meaning landowner who would like to preserve habitat on his or her land, but they're worried that if the species increases as a result and then maybe down the road they want to do something different, they're going to be on the hook, you know, for the take of the species that they took actions to benefit. So, you know, there's been a lot of initiative at the regulatory stage and at the policy guidance stage. You know, how can we work with regulated entities, whether it's private landowners, whether it's, you know, states, whatever, to come up with a way to give those entities assurances that they're not going to be essentially punished down the road for doing good things in the present. There's also been a lot of initiatives to off-ramp a potential listing through you know, private or state conservation agreement. So there has been a lot of attention, you know, for several decades now by the federal agencies to try to be forward thinking and not just like, we're coming down on you with a hammer right now, but what can we do to conserve species so they don't need listing in the first place? What can we do to, you know, conserve species that are listed, but in ways that, you know, result in a conservation benefit for a potentially regulated entity, as well as, you know, compliance with the act itself. So, you know, if you go to either the Fish and Wildlife Service or NIMSA's website, you know, you can not only look at the regulations, but all of these innovations that they've come up with over the years to try to, you know, balance private interests and the needs to conserve species under the ESA.
Yeah, I mean, a little bit of how that works, right? I mean, you talk about reopening consultation. You know, things are getting relisted all the time. How do you get the assurance that when X species is listed 2 years from now, I don't need to reinitiate consultation? You can get basically like it's take coverage that's dormant until it's such time that it's listed, and then you get coverage, and the benefit, you know, you get that upfront certainty. And the other side of that is the government will not come after you for more than what you've committed to do. So it can be done through a candidate conservation agreement. There's a few different mechanisms.
You can get coverage under Section 10 prospectively.
Or
so you're doing like a habitat conservation plan. You're the state agency that administers like the state forests, and you're like, we want to get the habitat conservation plan and Section 10 permit that covers both these listed species and also these species that are not listed yet, but maybe we have a signal that something's going on with them, and so the plan will cover it, and the permit will say, in the future, if it's listed, here's your take. So it gives some certainty.
Yeah, and I think that's been some of the mischief too, is that, you know, there you know, instances where Fish and Wildlife has been very aggressive about including something that is not a listed species as a condition of giving you your take coverage. And
but
so
on the other hand, you think about, you know, I mean, some people have sort of analogized the ESA to being the emergency room for species, but it's not like, you know, the emergency room, you come in with your virus. It's like, it's more like your trauma center. You know, you've been in some terrible accident, and now it's, you know, kind of touch and go. So much better to avoid that train wreck in the first place than try to fix it up afterwards. So So what kind of questions?
Yeah, we got a few minutes for questions.
Answer.
So, thank you both so much. I want to get to our questions on the phone real quick. We have one that James has been, he submitted this at 12:07, so I want to get to it. And then I really appreciate you offering to stay around, and I'll let the people in the room take advantage of that. But I do want to get to this question and then shut down the webinar. And but thank you so much.
Also, it's not a hard one.
Yeah, James wants to know a little bit about, and Jamie, I think you talked about it somewhat, and Jane, you just touched on this, but concerns with the proposed budget and NEPA. Basically, how will a shrinking federal budget impact the already kind of long timeline? What are your thoughts on that? And do you have advice for Congress as they're considering the budget?
Less so for Congress. I mean, they end up doing what they want. The budget has not been very well received on the Hill from what we've seen. But look, it's the story of unintended consequences. I mean, from a regulated community standpoint, most of my clients, I mean, they want to see people in the chairs. They want to have people they can call, the resources that are going to dedicate it to their project. Again, these things take some time to go through, particularly very complex projects. So, a cut to agency resources does not help. I think some of the things we've been talking about regarding, third-party agreements, reimbursable agreements, where basically the sources, the resources of the agency can be supplemented. You can't run afoul, you can't increase appropriation for the agency, but you can add staff or resources or whatever through these reimbursable agreements. And so we're basically trying to augment either staff or money in order to get something a process. But I think the concern is well founded, and there's definitely a disconnect between this streamlining initiative and cutting funds. The other thing, which again it's not really NEPA or ESA, is the funds are also being cut for the projects themselves. I mean, a lot of these projects need funding, federal funding, or at least loans or whatever to get going. So there's been a little bit of a disconnect between the budget and the objectives. And
I mean, adding on to that, I think that's exactly right. But on the NEPA front, a very important purpose of NEPA, if not a central purpose, is public dialogue, to inform the public of what the agency is proposing to do and allow the public to inform the agency of its concerns. And a big tripping point in litigation for agencies is when there has been insufficient public process. So people don't know what the agency is planning to do and then why. So, and that's something that leads to a lot of litigation, which of course leads to expense and delay. So, again, it's not a substantive statute. It doesn't dictate a particular outcome. The example I will give sometimes is that the National Park Service could fill in the Grand Canyon with cement if it wanted to, all other things being equal, as long as it did sufficient NEPA on it. It's like, under NEPA, it could pave over the Grand Canyon as long as it showed its work. It has purpose. It done the alternative analysis. Here's the impacts. The impacts are, entirely destructive of the park, but we're going to do it anyway. Under NEPA, you could do that, but the public has to know about it, whether it's through a written comment process, whether it's through public hearings, because the ultimate decision has to be an informed decision. So I think that cutting off the funding and the staff to be able to do that, not only does it cause potential problems for project proponents, but it really undermines the public's right to know about what agencies are doing with the federal resources, whether it's taxpayer dollars, federal lands, whatever the resources in question. And when you have an adequate public process, often that heads off the litigation. I mean, people have a better understanding of it. So I think in some ways it's really short-sighted, both from the perspective of Jamie's clients as well as from the perspective of the public, writ large, who are very interested in what the federal agencies are doing.
Thank you. I'm going to ask everyone in the room to please join me in thanking our panel for being here today. Appreciate if you can hang out and chat with folks that haven't, if you have time.
Thank you, everybody.
Everyone on the web, thanks for joining. Tune in next week for the next summer school session, and let me know if you ever have any ideas for seminars that ELI should do. Thank you.